Assignment. Topic name, concept of delegated. Legislation. Subject, administrative law. Assignment submitted to Faculty of Law, University of Lucknow. For the partial fulfillment of the requirement in Bachelor of Laws, Honors, BSEM, Section B. Session, 2022-23. Under guidance of, submitted by Mr. Pratik Sethishani. Guest faculty roll no. .200013015158. Faculty of Law. University of Lucknow.
Acknowledgement.
I would like to express my deep regard towards the prestigious institution of Faculty of Law for granting me with such an enriching opportunity to perform a research, compile and put together this project work on such an innovative but ever so relevant as concept of delegated legislation that not only enhanced my understanding of the topic but also provided me an in-depth analysis of the concept. I would also like to express my heartfelt gratitude for my mentor and teacher and guide Mr. Pratik Seth for providing me with such an innovative and educating subject to read, comprehend and research upon and assisting, guiding and motivating me throughout the making of this project with his words of wisdom and statements of encouragement when I couldn't comprehend a portion of the work or found it tedious, and his guiding remarks in the ones I couldn't master by myself along the way of the research of the project. In the end, I would also like to convey my sincerest regards to my friends and family who provided with their never-ending support as and when it was required until the very end of the researching and drafting of this project work and kept me motivated to keep going and filled with enthusiasm to take the research work by the hook and tackle it, work upon it and complete it finally with all the details and intricacies of law of contracts with respect to the topic to the very end. 200013015151.
Introduction.
Delegated legislation, sometimes referred as secondary legislation or subordinate legislation or subsidiary legislation, is a process by which the executive authority is given powers by primary legislation to make laws in order to implement and administer the requirements of that primary legislation. Such law is the law made by a person or body other than the legislature, but with the legislature's authority. Legislation by any statutory authority or local or other body other than the legislature, but under the authority of the competent legislature is called delegated legislation. It is legislation made by a person or body other than Parliament. Parliament thereby, through primary legislation, enables others to make law and rules through a process of delegated legislation. Why delegated legislation is important? The process of delegated legislation enables the government to make a law without having to wait for a new Act of Parliament to be passed. Further, delegated legislation empowers the authority to modify or alter sanctions under a given statute or make technical changes relating to law. Delegated legislation is important due to various reasons. They are as follows. 1. Delegated legislation reduces the burden of already overburdened legislature by enabling the executive to make or alter the law under the authority of legislature. Thus, this helps the legislature to concentrate on more important matters and frame policies regarding it. 2. It allows the law to be made by those who have the required knowledge and experience. For instance, a local authority can be permitted to enact laws with respect to their locality taking into account the local needs instead of making law across the board which may not suit their particular area. 3. Finally, delegated legislation often covers those situations which have not been anticipated by the Parliament during the time of enacting legislation, which makes it flexible and very useful to lawmaking. Delegated legislation is, therefore, able to meet the changing needs of society and also situations which Parliament had not anticipated when they enacted the Act of Parliament. There are three forms of delegated legislation, i.e., statutory instrument, orders in council, and bylaws.
Statutory instruments.
They are the one which is formed by the government. For example, a parent act is an act which permits the parliament for making the law. Orders in the council are generally made by the government when there is a need and it can affect the public at large as well as an individual. Bylaws. They are created by the local authority, which is approved by the central government. There are many reasons for the delegation of the legislature. The parliament does not have that much time to deliberate and debate about every topic. Therefore, delegated legislation helps in making laws rapidly than the parliament, and the procedure of the parliament is also very slow as the bills for every law needs to pass from every stage. Further, it is also believed that the member of parliament does not possess the technical ability which is required to make law. For example, making any law regarding taxation requires knowledge as well as experience, which can be done by the person who is professional in that field. In the case of welfare purpose, the local authority can understand the needs of the people in his area more effectively than others. The democratic bodies have many important powers for the delegated legislation, which can be easily used for updating the legislation according to the requirement, which leads to social welfare. But there should be control over delegated legislation. Delegated legislation is controlled by the Parliament and the judiciary. Parliament has the overall control over the delegated legislation as it takes account with the statutory committees which make law through bills. The main object of parliamentary control is to look that there is no abuse or unnecessary use of the powers given to rulemaking authorities. In the case of Narendra Kumar v. Union of India, it was held by the Supreme Court that the provision under Section 3(5) of the Essential Commodities Act, 1955, which explains that any rules framed under the Act must be presented before both the houses of the Parliament. Therefore, Clause 4 of Non-Ferrous Control Orders, 1958 has no effect until it is presented in the Parliament. Advantages of delegated laws. There are many advantages of delegated legislation, as it is essential for a democratic country to flourish or make laws according to its public. These advantages are as follows. Reduces the workload of Parliament. The Parliament has to pass several legislation within a short span of its life. It has to take such type of intensive work that it can hardly enact the law provisions in detail. So there arises the need to overcome that load, and it can be possible only through delegating legislative authority to the subsidiary or the executives. Brings in technical expertise. 4. Today's world has become very technical and complicated by the introduction of modern means and advancement in technology. It is difficult for the members of Parliament to have all knowledge needed for making laws in various fields, like on controlling technology, ensuring environmental safety, dealing with various industrial problems which need basic knowledge. Therefore, it is thought that it is better for the Parliament to debate on the broad topic or the main topic and leave the rest detail for the fulfillment by the expert of that particular field. Thus, delegates' authorities with extra skills, experience, and knowledge are more suitable for making law. Decentralized decision-making. The local councils are more suited to make laws for their constituencies as they better know the condition of their constituencies than any other. These local bodies can make better laws for their area that a parliament cannot do so, because they know their locals' need and what they want. The parliament makes the laws for broad principle while its delegate handles the local principle. Rapid action during emergencies. Quick action is needed in times of emergencies like war, internal disturbances, floods, epidemics, strikes, lockouts, bonds, etc. The lengthy legislation process of Parliament is just not suited for such situations. If the executive is armed with special powers, the situation can be kept under control very quickly. Enables flexibility. When the legislature passes a statute, it is almost impossible to foresee all the contingencies which may arise in the future in the practical application of such a law. Of course, it is possible to amend the statute as and when the need arises. However, this is a slow and cumbersome process. In such a situation, delegated legislation allows the executive to overcome practical difficulties by exercising the power conferred on it by the parent act. So these minor details can be changed immediately without making any amendment in the Parliament. Therefore, it is flexible, and the legislation made by this can be best for the needs of the modern public. Scope for experimentation. There is a lot of scope for experimentation in the administrative process. The administrative authorities can frame a new rule, try it out for some time, and if found unsuitable or unsatisfactory or unworkable, may modify or even repeal it without much formality. 5. Constitutional provisions on delegated legislation. Although the concept of delegated legislation was not mentioned specifically in the Indian Constitution, it can be understood by interpreting Article 312. This article gives the right to the Rajya Sabha to open a new branch of All India service with a majority of 2/3 majority vote. This means that some powers of legislation will be delegated to the new recruiter of All India service. There are many cases through which delegated legislation under the Constitution of India can be understood. In the case of D.S. Girwal v. State of Punjab, the Supreme Court held that Article 312 of the Constitution of 2 India deals with the powers of delegated legislation. Justice K.N. Wanchu observed there is nothing in the words of Article 312 which takes away the usual power of delegation, which ordinarily resides in the legislature. The phrase Parliament may by law provide in Article 312 should not be interpreted to mean that there is no scope for delegation in law made under Article 312. The England law enables the British Parliament to delegate any amount of powers without any limitation. Indian Constitution does not give unlimited or uncontrolled powers for delegated legislation in India. India allows for delegated legislation but in a defined and controlled manner with certain restrictions. Classification of delegated legislation. Power to bring act into action as it is already given that in a specified date this act will come into force prescribed by central or state government by giving a notice in the Official Gazette. In A.K. Roy v. Union of India, case Supreme Court held that executive has the power to bring the act into force and it should not be excessive in delegated power of legislation. So, here the court rejected the contention that the power was excessive in nature as per prescribed. It was practically difficult for enforcement. Therefore, power is given to the executive authority to decide the date of enforcing the act. Conditional legislation, the rules are framed or designed by the legislature, but to implement or enforce it is done by the executive organ, so executive has to look that what all conditions need to be fulfilled to bring it in operation. If all conditions are satisfied, then it is well and good, otherwise notice will be issued to bring the law into operation, and it is known as conditional legislation. Types of conditional legislation. Power to bring the act into action. Power to extend the time period or life of the act. 6. Power to extend the application of the Act to any territory and to make restriction or make an alteration in the Act itself. Exempt the operation on certain ground or subjects of territories. Criticism of delegated legislation. Delegated legislation results in overlapping of functioning as the delegated authorities get work to amend the legislation that is the function of the legislators. It has been a matter of question that if the legislature control has come down after the arrival of the delegated legislation. Unelected people cannot make much delegated legislation as it would be against the spirit of democracy. After getting too much power from the legislature, the executive has encroached upon the domain of legislature by making rules and regulations. The enactment subject that was appointed to less parliamentary scrutiny than essential enactment. Parliament, along these lines, has an absence of authority over appointed enactment, and this can prompt irregularities in laws. Appointed enactment, in this way, can possibly be utilized in matters which Parliament had not foreseen when it was given the power through the Act of Parliament. Delegated legislation makes laws without much discussion. So, it may or may not be better for the public. Mechanisms to address the challenges. With the rise in delegated legislation, the need to control it also arises because the increase in the delegation of power also increases the chance of the abuse of power. Judicial control apart from legislative and procedural control is the way how the delegation of power can be controlled. Parliamentary control. Measures should be taken to strengthen the control of Parliament over delegated legislation. It is necessary that the role of the committees of the Parliament must be strengthened. A separate law like the Statutory Instruments Act, providing for uniform rules of laying and publication, must be passed. The committee may be supplemented by a specialized official body to make the vigilance of delegated legislation more effective. Procedural and executive control. There is no particular procedure for delegated legislation until the legislature makes it mandatory for the executive to follow certain rules or procedure. Pre-publication and consultation with an expert authority. Publication of delegated legislation must be made compulsory before delegated law is enacted. Judicial control. 7. The delegated legislation can be questioned in courts on the grounds of substantive ultra vires and on the ground of the constitutionality of the parent act and the delegated legislation. The delegated legislation can also be challenged on the ground of its being unreasonable and arbitrary. Law defined under Article 13 of Constitution of India clearly indicates that the state should not make any law which abridges the right given in Part 3 of the Constitution. Conclusion. 8. Delegated or subordinate legislation means rules of law made under the skilled person of the Act of Parliament. In spite of the fact that lawmaking is within the capacity of the law-making body, it might, by a resolution, delegate its capacity to different bodies or people. The resolution which delegates such power is known as the Enabling Act. By Enabling Act, the Council sets out the wide rules and nitty-gritty principles are instituted by the delegated authority. If in India the control of Parliament over the delegated legislation has to be made a living continuity, then it is important that the job of the advisory groups of the Parliament must be fortified and a different law like the Statutory Instruments Act, accommodating uniform standards of laying and production, must be passed. The Board of Trustees might be enhanced by a specific authority body to make the watchfulness of assigned enactment progressively successful. Other than the different measures mentioned above, it should be taken to reinforce the control of Parliament over designated enactment. The tenets and standards created by the legal executive should be connected by the necessities of the advanced age. In spite of the fact that there are no express arrangements in the Constitution of India to allow the appointment of authoritative power, The legal pattern saw in regard of assigned enactment is as per the aim of establishing fathers our Constitution, whose principal concern was the flexibility of the Constitution with changing needs of the time. If you want to make certain that the power of delegated law in the arms of the government is not misuse, it is vital to adopt powerful modes of control as applicable in the USA, which India has now not integrated yet. 9. https://www.google.com/URL ?
Ça égale T et RCT égale J et Q égale et SR égale S et source égale web et CD égale et CAD égale RJA et UACT égale 8 et VED égale 2 AUKEUSUD.
We8FV7 AUXUR1 YBHVSLAGWQFNO ECC 4 QAQ and URL equals https://3a%2f. %2flobhumi.com %2f meaning and evolution of delegated legislation %2f and USG equals AOVIVA 1 MGWFM7 XIP9 VFYJMHBTGNL https://www.google.com/URL ?
Ça égale T et RCT égale J et Q égale et SR égale S et source égale web et CD égale et CAD égale RJA et UACT égale 8 et VED égale 2 AUKEUSUD.
We8FV7 AUXUR1 YBHVSLAGWQFNO ECD QAQ and URL equals https://3a%2f. %2fjournalsofindia.com %2f delegated legislation. %2f and USG equals AOVIVA 2H3_R6HLORGPXGSQE4Z. 10.